Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Tanya Maheshwari. She is going to speak on landmark judgment on part performance, Arif versus Jadunath 1931. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request her to commence with her lecture. Thank you.
Thank you so much, sir, for inviting me to share my knowledge. So greetings everyone, myself Tanya Maheshwari. Today I am explaining the landmark judgment on part performance, Arif versus Jadunath 1931. Before explaining the judgment, I want a couple of minutes of yours to imagine this situation. I orally agree to sell you a flat which is worth 10 lakh rupees. No paperwork, no registration, you even pay me a part consideration. So, you want to enforce this agreement in a court. So the big question arises in this situation, will the court enforce this agreement if there is no paperwork or registration? So to analyze this question, I am explaining today the Arif versus Jadunath case. Today, the Jadunath Bahadur case, a 1931 Privy Council case, is a very important case in the property law because it answers a simple but a powerful question. In this case, the Privy Council addresses the intersection of statutory requirements and equitable doctrines in the context of land tenancy. So, before explaining the judgment, I will explain the equitable doctrines. So, equitable doctrines is a legal rule or a principle often rooted in fairness and consciousness which we brought from the English law to protect the interest of the buyer. So the facts of the cases are, in 1913, a verbal agreement or an oral agreement was made between the appellant and the respondent. In this case, the appellant is agreed to sell his property to the respondent, and the respondent take the possession of his land in 1913. But it was a verbal agreement. The respondent built structures, constructions, lands on the approved permission of the appellant. So in 1914, parties agreed orally to a 5-year lease. So in every 5th year, they will renew the lease. But there was no written agreement or the deed is not executed. So in October 1922, the appellant served upon the respondent a notice to quit, asserting that he was a monthly tenant and he should vacate the premises by November 1, 1922. So this requirement was not done by the respondents. The petitioner filed a suit in the court of Munsif, but the court of Munsif reject this suit. So here's a twist. In this case, the Transfer of Property Act worth more than 100 rupees. So this is an immovable property and its worth is more than 100 rupees. So according to section 54 of the Transfer of Property 1882, it states that such a transfer is only valid if it done through a registered deed. So if the value of a movable property is more than 100 rupees, you have to register it with the registrar office. So an appeal was raised in the High Court of William in Bengal. So here are some issues which the council gives the answer beautifully in his judgment. First, whether there existed a valid contract between the parties according to Transfer of Property Act. Second, whether the doctrine of equitable estoppel was applicable to the facts of the cases. Third, whether the equitable doctrine of part performance override the express provisions of the Transfer of Property Act. So before moving to the judgment, firstly I will explain what is the doctrine of estoppel and what is the doctrine of part performance. So doctrine of estoppel is a legal principle that prevents a person from denying the truth of a previous statements, promise or an action if another reasonably relied on it would suffer a loss or a detriment by a denial. And the part performance means where two people agree to enter in a contract, but the other one is fulfill the contract according, but the other one is fulfill all his actions which is basically based upon the contract, but the other party not perform his contract. So to protect the interest, the one who act in the furtherance of a contract, the doctrine of part performance is enshrined in Section 53A of the Transfer of Property Act to protect the interest of the buyer from the fraud seller. So in this case, the Privy Council centered on the supremacy of law over the equitable doctrines. The Transfer of Property 1882 explicitly mandates that if there is a lease exceeding 1 year, it must be documented through registered instruments. The respondent verbal agreements, subsequent actions, including the significant in financial investments and construction on the land. The court emphasized that the equitable doctrines like part performance, doctrine of estoppel, doctrine of lis pendens, doctrine of subrogation are just to protect the interest. They are not the validated right on the statutes explicitly prohibits. In this judgment, the Privy Council clarifies that equitable doctrines serve as a supplementary protection. It cannot override the statutory mandates. Moreover, it sets a precedent that when equitable principles can offer protections in the absence of formal agreements, but they do not possess the authority to contravene established statutory framework. The case thus holds significant weight in shaping the future of property law by interpreting and applications of property, balancing the scales between equitable fairness and statutory adherence. Here is a crucial key principle. What the law declares void, equity cannot make it valid. In short, fairness cannot override the statutory frame requirements. The buyer had no remedy. So with this closing statement, I want to conclude my judgment that equity may follow the law, but it will never fly in the face of the law. No registration, no transfer, no matter how the transaction or how the contract is seen fair, there is no remedy for the buyer. Thank you.
Tanya, thank you very much. Nice explanation as regards the part performance of a very old judgment, that is of 1931. So it was a nice way in which you had presented. Thank you, and a small token from Hammurabi to you.
Thank you, sir.